Welcome back to the deep dive. Today, we are looking at something that is, well, it's a bit of a paradox.
That is probably the best way to start. It is a paradox wrapped in, legal formatting.
Exactly. On the surface, this document, it looks like the driest thing imaginable.
Mm-hmm.
It has this heavy title, the dense paragraphs, the formatting of a high-level court filing. You look at it and your brain instinctively goes, okay, this is paperwork.
Right. I need to file this.
I need to file this or sign this or ask for permission for something.
It triggers that whole bureaucracy reflex. You see the layout and you assume there's a fee attached or stamp needed somewhere.
But then you actually read the first few lines and it explicitly refuses to behave like any of those things. It says, essentially, I am not asking for anything.
Yeah.
It's called the Clean Instrument Notice, and we're looking at version 1.0, specifically the Notice, Declaration, and Resolution of the People.
And it's a fascinating piece of writing because it completely flips the dynamic of how we usually interact with authority.
How?
Well, usually any interaction with the government is transactional.
Oh.
You want to build a deck. You fill out a permit application.
Right.
You want to drive. You apply for a license. You want to open a business. You get a certificate. You are always the petitioner, asking a higher power for a privilege.
Mother, may I?
Exactly. Mother, may I. And this document, it just walks into the room and says, I don't need to ask.
And that brings us to the mission of this deep dive, then.
It does. We aren't just analyzing a legal argument. We're looking at a fundamental shift in mindset about where human rights actually come from. This document is rooted in Hawaii, but the principles it lays out about silence, consent, authority, they're universal.
The thing that hooked me immediately was this concept of silence. There's a line right in the text that says the entire reason this thing exists is because silence is being misconstrued as consent.
That is the catalyst. It is the engine driving the whole car. I mean, think about how modern governance works. If a city council passes a mandate or a governor issues an emergency proclamation and the public says nothing,
The system assumes everyone's on board.
everyone's on board. It's like an auto-renewal subscription.
Oh, that's a good analogy.
If you don't explicitly call and cancel, they assume you want to keep paying.
So the government often operates on this auto-renew basis for its authority.
Exactly. If you don't object, the assumption is that you consent. And this document argues that public authority has exceeded its lawful bounds, and it's banking on your silence to keep going.
And the Clean Instrument Notice is the cancellation letter.
It is the cancellation letter. It's a way to break the silence and put on the permanent record, I do not consent.
So the whole argument is that rights aren't gifts. You don't get them for being a good citizen.
Precisely. And that takes us right to the Declaration of First Principles. We have to start there because if you don't buy the philosophy, the rest of the legal jargon just won't matter.
The document uses some heavy words here. It says people are sentient beings endowed with unalienable, God-given, and natural rights. I want to stop on Holly. Unalienable. We hear that word a lot, but what does it actually mean in a functional legal sense?
In this context, unalienable means it's incapable of being separated from you.
Okay.
You can't sell an unalienable right. You can't gift it to someone. And most importantly, a government cannot take it away. It's just fused to your existence.
So it's like your height
Right.
or your DNA. You can't just decide to not have it anymore.
Right. And the document makes a very bold claim based on that. It says that because these rights are inherent born with you, no office, title, election, statute, or proclamation can confer original authority over them.
Wait, so even an election, if we vote for a guy and he passes a law, that law doesn't trump these rights?
Not according to this instrument. And that's the aha moment. We often think, well, we live in a democracy, so the majority rules. This document says, no, the majority rules on some things, but it cannot rule on these things.
So what's the purpose of government then?
It argues that the purpose of lawful government is to secure rights already possessed, not to invent them or regulate them out of existence.
It's the security guard analogy.
Explain that.
Well, if I hire a security guard for my house, his job is to make sure nobody steals my TV. His job is not to tell me what channels I'm allowed to watch. The Constitution is the security guard. It didn't buy the TV. It's just there to protect it.
That hits the nail on the head. And to ensure the security guard doesn't get confused, the document actually lists what rights are not subject to. It's a list of negatives.
What's on it?
Rights are not subject to grant, transfer, waiver, vote, mandate, proclamation, emergency, or suspension.
The emergency one feels very specific to the last few years.
Oh, it absolutely is.
Yeah.
We've seen a global trend where emergency becomes this magic word that, pauses the Constitution.
Yeah.
This document is pushing back hard on that. It asserts that because rights come from nature's God or natural law, They exist above the timeline of human crises, a virus, a war, an economic crash. It doesn't change the nature of a human being, therefore it cannot change the rights of a human being.
It's really drawing a hard line in the sand. But what I find fascinating is that usually when you have a document this bold, there's a face attached to it, a leader, a revolutionary, a guru, something.
Right. You expect a signature that says the President of the New Republic or some other grand title.
Exactly. But I looked at the bottom of this document, and there's a signature, Megiso William Dennis. But the title isn't leader, it's custodian.
This is one of the most unique and, frankly, strategic parts of the entire project. The document spends multiple paragraphs defining what the custodian is not.
It sounds like a disclaimer you'd see on a bottle of medicine. Asserts no personal authority, speaks in no representative capacity, performs no active enforcement.
Exactly. Think of the custodian like a librarian, or maybe a museum curator. The curator ensures the artifact is safe, that the lighting is right, and the doors are open so the public can see it.
But the curator didn't paint the Mona Lisa.
No. And the curator doesn't have the authority to tell you, you must feel happy when you look at this painting.
So why go to such lengths to strip this guy of authority? Usually, movements want a charismatic leader to rally behind.
It's about preserving the clean status of the instrument. That is why it's called the clean instrument notice. As soon as you have a leader interpreting the text becomes secondary to the person.
It becomes Megiso's law.
And it becomes a cult of personality.
Right.
Correct. And legally, if the custodian starts giving instructions or legal advice, the document gets muddied by his opinions. By saying, I am just the guy holding the paper, he forces you to deal with the text itself.
Mm-hmm.
There's even a clause that says, no spoken presentation, creates, conditions, limits, or modifies the instrument.
That is remarkably disciplined. It's basically an anti-guru clause. Don't listen to me, read the sign.
It ensures the authority remains in the principles, not the personality. It's a very decentralized approach to authority, and it forces you, the reader, to take responsibility for understanding the content.
Okay, so if the authority isn't the guy signing it, what is the authority? You mentioned first principles, but legally, what is this document standing on? Because if I walk into a court and say, nature's God said so, the judge might just roll his eyes.
You would be surprised, but yes, in a modern administrative court, you usually need more than that. The document cites a stack of legal foundations. And it's really interesting because it blends different legal realities that don't always mix.
I noticed that. It has the U.S. Constitution, but then it also has the Kingdom of Hawaii.
It's a hierarchy. So at the very top, you have the laws of nature. That's the umbrella. Under that, it cites common law. Then it moves to constitutional supremacy, citing the Declaration of Independence and the U.S. Constitution, Article 6, Clause 2.
The Supremacy Clause.
Right. Which states, the Constitution is the supreme law of the land. But then it stacks the Constitution of the state of Hawaii and, crucially, the historical and living continuity of the Kingdom of Hawaii Kaupanaina.
That feels like a contradiction. How can you cite the U.S. Constitution and the Hawaiian Kingdom at the same time, aren't they? Sort of at odds historically?
Historically and politically, yes. I mean, there's huge tension there. But in terms of protecting rights, this document argues they're actually pointing in the same direction.
A belt and suspenders approach.
That's a great way to put it. The argument is essentially, I don't care which jurisdiction you claim to represent. Under the U.S. Constitution, my rights are protected. Under the kingdom's continuity, my rights are protected. Under natural law, protected.
So it's cornering the government. No matter which rule book they pick up, the answer is still, you can't do that.
Exactly. It closes the loopholes. And speaking of loopholes, we have to talk about Marbury v. Madison.
1803. I haven't thought about that case since high school civics. Why dig up a 200-year-old case for a modern document?
Because Marbury v. Madison is the grandfather of the delete button for bad laws. It established the principle that any law repugnant to the Constitution is null and void.
Repugnant. Lawyers used to have much better vocabulary.
It is a strong word, isn't it? It implies disgust, a deep contradiction. But the legal implication is massive. It means a law that violates the Constitution isn't just bad. It's not a law at all. It's void ab initio from the beginning.
And this document uses Marbury to tell the reader what?
That you don't have to wait for a judge to tell you a mandate is illegal. If it violates your unalienable rights, it is void on its face.
That's a very empowering, but also a very risky stance. It puts the burden of interpretation on the citizen.
It does. It requires the citizen to actually know what the Constitution says. But this document argues that the alternative, waiting for permission to exercise a right, is worse. And that brings us to the distinction between rights and privileges.
Okay.
The document is adamant that rights cannot be licensed or converted into privileges.
Give me a practical example of that conversion. How does a government convert a right into a privilege?
Let's take the concept of travel versus driving. Driving a commercial vehicle on a public road is a privilege. You need a license because you are engaging in commerce.
Sure.
But the right to locomotion, to move your body from point A to point B, that's a right. If the state says you cannot leave your house without this digital pass, they have just converted a right movement into a privileged permission. This document says that is a trespass.
Trespass, that's another word they redefine here.
Trespass upon the person. Usually we think of trespass as someone walking on your lawn, but this document argues that your rights are your property, your intellectual and spiritual property. If a bureaucrat creates a rule that limits your speech or your movement without due process, they are, in effect, physically trespassing on you.
It makes the violation feel physical. It's not just paperwork anymore, it's an intrusion.
Correct. It reframes a bureaucratic overreach as a physical violation. It isn't just an administrative error, it is an unlawful intrusion.
So, if the government is trespassing, how do we read the rules? The document has a section called Interpretation and Construction.
And the rule is simple. The tie goes to liberty. It says any ambiguity must be resolved in favor of liberty, due process, and the least intrusive construction upon individual rights.
I love that phrase, least intrusive construction. It's like a tiebreaker rule in sports.
Tie goes to the runner, but in this case, tie goes to liberty. If there are two ways to interpret a rule, one that controls you a little and one that controls you a lot, the government is required to pick the one that controls you less.
That seems like a standard we should have everywhere.
It used to be standard. That's the irony. This document isn't inventing new, radical ideas. It's dusting off very old foundational legal standards that have been buried under piles of administrative code.
So we've got the philosophy, the stack of laws, the rules of interpretation. What does the document actually do? It's called a resolution. So what are we resolving?
We aren't resolving to start a revolution. This is crucial. The tone is declarative, not coercive, educational, not adversarial.
It explicitly says it is not campaign material.
Right. It's not trying to win an election. It's trying to reset the baseline. The resolution is that public power within Hawaii remains subordinate to unalienable rights. It resolves that acts exceeding lawful authority are void. And it resolves that peaceful notice is the proper remedy.
It treats the government like a student who has forgotten the lesson.
That is a great way to put it. It completely flips the teacher-student dynamic. Usually the government educates us on the new laws. Here, the citizen is the teacher holding the public record, reminding the government of its own rules.
And it says this record is operative just because it exists. It doesn't need to be filed.
Independent of registration, filing, acknowledgement, acceptance, or response. This goes right back to the silence and consent issue. If you believe your rights are God-given, you don't need a stamp from the county clerk to make them real. You write it, you sign it, you witness it, and it is a self-executing instrument.
It's remarkably confident. It assumes the status of a free person rather than begging for it.
And that confidence is the entire point. It's a psychological tool as much as legal one. It breaks the habit of asking for permission. It tells you that your rights don't depend on the system acknowledging them. The system depends on you acknowledging it.
Before we wrap up, I want to circle back to one phrase in the Supreme Law section that I've been chewing on. It says, protection is not ownership.
It is the most profound 3 words in the text.
We trade a lot for protection, don't we? We want safety from crime, safety from economic collapse, safety from health crises, and usually the price is compliance.
That's the social contract. We give up a little freedom to gain a little security. But this document asks, where is the line? If an entity protects you or claims to protect you, does it own you?
Yeah.
If a farmer protects his cattle from wolves, the cattle are safe, but they're still cattle. They're owned.
And they eventually get eaten by the farmer.
Exactly. This notice is drawing a line in the sand. It says, you can protect me. That is your job as a government, but that protection does not give you title to my life, my body, or my choices.
So it's a warning against the nanny state becoming the owner state.
It is suggesting that if the price of safety is total submission, the cost is just too high. And since silence is misconstrued as consent, this document is the way to loudly, peacefully, and clearly say, I am not property.
It's a lot to think about next time you're staring at a government form, wondering why they need to know so much about you.
It certainly changes the perspective. It transforms you from a subject asking for a favor into a beneficiary demanding what is already yours.
That's all for this deep dive on the Clean Instrument Notice, a complex, fascinating document that tries to use the weight of bureaucracy against itself. Thanks for helping us unpack it.
Always a pleasure.
And to you listening, stay curious and maybe check who owns your silence. We'll see you next time.